Hey everyone, Louisiana Succession Attorney Brad Scott here with another probate process video. Today I want to talk to you about the difference between independent administration and court-supervised administration over estates. So one of the procedures that can be used when you open a succession is placing it under what's called administration. And this is where someone gets appointed as like the executor or the succession representative, and that person's in charge of taking care of the estate assets, paying the bills, and getting the assets over to the heirs when they close the estate. Now, when that process is started or initiated, the administration process, there's really two ways that can be handled. One is called independent administration, and the other one's called court-supervised administration. So let's start with the court-supervised administration first. So when the court appoints somebody to do something, the basic way in which it's done is the court is also involved with the process. They're overlooking everything to make sure it's handled correctly and it's being done fairly. So in that instance, what happens is anytime the administrator, the succession representative, same thing, just two different words, if they want to, let's say for instance, sell a piece of real estate, the process is they have to ask for permission from the court first. And that's usually some type of petition for authority that's filed with the court, laying out why they want to sell it and what they're trying to sell it for. Also, what they need to do is they need to let the world know they're trying to do this to see if anybody's going to oppose it. So in that situation, if they're selling real estate, for instance, they have to put a legal notice in the newspaper. Sometimes it has to be ran twice, and there's an amount of time that it has to run and gives people an opportunity to object to it in case they think the administrator is doing something they shouldn't be doing. After that time frame runs, if there's no opposition that's been filed, then the administrator has to go back to court and show the court that they did the advertisement, that the requisite amount of time has lapsed, and then ask for the authority to actually do the process of selling the property. This could be a very time-consuming process to get anything done, but it allows some types of checks and balances to make sure things are handled fairly. Now, same thing if they wanted to pay any expenses or debts, they would have to ask the court for authority. They would have to actually serve or even notify third parties that they're trying to do that. And again, you have to wait to see if there's going to be any opposition before the court will authorize you to do these things. What you should hear when you hear this administration under court supervision is a lot of back and forth time that's necessary to get things done. That can increase the cost and the expense of getting a succession completed. So there is another option, however. If you want to try to minimize those costs and you want to make things move a little faster, you could ask for what's called independent administration over the estate. Now, there's a couple ways this could happen. There might be a last will and testament where in the will itself, the person who made the will specifies that they want the estate handled under independent administration. If that power is granted in the will, then the court will recognize that and grant independent administration. On the other hand, if you don't have a will, or if the will doesn't provide for independent administration, you could ask the court to appoint you on an independent basis. In that situation, however, you're going to need the consent of everybody who's involved as far as all of the heirs. If everybody agrees to it, you can get consent to it, then you could be appointed as an independent administrator. Now, how does that compare with court-supervised administration? Under an independent administration, it's a lot more streamlined. You go to court, you get appointed by the court, you get your letters of administration, and then you're off and running. The court sends you out to go do whatever you need to do. You don't have to go back and forth asking for permission and asking for authority to do things. You take care of the estate, you administer the estate, you pay the bills, distribute the assets, and after you're finished, the court requires you to come back and just give them an accounting of what you did. You may be required to publish that accounting and see if anybody opposes it, to question anything that you did. However, it's a very much a faster and a much more streamlined process, and it is what we recommend if we can do it to keep the cost down. Not always you are allowed to do that, but if we can, that's the way we want to go. If you have any other questions about independent administration versus court-supervised administration, please reach out to us. Be happy to help you any way we can. If we can't help you, we'll try to point you in the right direction to get the help that you need. Until next time, thank you for watching.